Fani files a last-minute brief, panicked that Judge McAfee is going to disqualify her and end her entire political career. And we're going to go through it and also take a look at Trump's initial reply. Steve Sadow called this out in his reply back to her, saying, I got more to say about this, but we're just going to leave it here for now. So here's what Fani sent in to Fulton County. And this is after all of the additional affidavits have come in, all of the additional notices. Remember, we've got other people. We have a law professor who says that, yeah, Terrence Bradley lied, told me something differently. We also have a prosecutor who's a current prosecutor in Cobb County, one county over, says that Fani Willis called Terrence Bradley on the phone and said, don't talk to them because they're coming after us, and basically shut your mouth. And Terrence Bradley felt freaked out about all of that. We also have the cell phone records that got submitted showing that these two were indicting each other at all hours of the night, and including spending the night, going over there at 11, leaving at 4 in the morning, spending the night at Fani's residence, all well before they admitted that their relationship started in 2022, which means they perjured themselves. So this is what Fani is submitting to try to escape any culpability for her disgusting misdeeds. And she sent this in to Fulton County Judge McAfee, who now has a challenger. This is what Fani wrote. She says, all right, Judge, at the hearing back on March 1st, concerning Trump's and Michael Roman's and Ashley Merchant's and their motions to disqualify Fani, we covered that hearing. It was a wild one. The court, you, Judge, you posed several questions to the parties concerning the standard of proof that's required for disqualification. This is a matter of first impression. We don't know what the actual standards are. What are the elements that justify disqualifying someone? And the legal standard that's to be applied by the court. The binding case law in Georgia is clear, they say. A trial court is not authorized to disqualify an elected DA absent showing, quote, by a high standard of proof. And when we talk about standard of proofs, we talk about different standards like preponderance of the evidence, which is 51% likely. We talk about clear and convincing evidence, which is maybe a little higher than that. We also talk about beyond a reasonable doubt right there. And the standards get higher. So think about this like as 90% or 80%, right? If you have any doubt that's based in reason, then that person is not guilty. So it's a very high standard. Whereas preponderance of the evidence is kind of like a balancing test. If it's more likely than not. If it's 51% or higher, then that's enough. And this is often what you'll see in civil traffic cases. So yeah, it's more likely than not. Cop says you did it. You say you didn't. You got a reason to lie. He doesn't. He's got training. You don't. Okay, more likely than not, you're guilty. So what Fani's arguing for is something higher than this, obviously. Much higher. Now, we don't know what she's saying. We'll see if she gets there, but something higher than that, and there are other standards in between. But the point is, where do we end up? And that's just the burden of proof. But what is also the rules? What is this legal standards? Like there are check boxes to say, if you get a DUI, you got to be, for example, driving a car. Okay, blood alcohol has to be above a certain limit. You got to be, and so on. Check all the boxes, actual physical control, and within the city limits, within the jurisdiction of the court, blah, blah, blah. All the things. So what are the check boxes? And in order to check those boxes, what is the legal burden of proof that needs to apply? So Fani says it's got to be much higher, and so high that the DA either has an actual conflict of interest, so not an appearance of impropriety. She's arguing for a lower, in other words, stricter rules, and has engaged in forensic misconduct, and they cite case law. They say this brief will not examine the legal standard about forensic misconduct, which was already covered extensively. And so Will Wooten wrote this one. Adam Abate still, icing his forehead after the last brain drain that he put us through. So they say, we're not going to engage in this. It was already covered. The state maintains that the evidence does not even come close to establishing that Fani's statements were part of a calculated plan, evincing a design to prejudice the defendant in the mind of the jurors. No prosecutor in Georgia has ever been disqualified from prosecuting any case on grounds of forensic misconduct, and this case should not be the first. Isn't that crazy? So prosecutors, they have such a benefit of the doubt. They get away with basically everything, which is why when we're talking about disqualifying Fani, it's like, wow, the DA of Fulton County in a national case, it's a tall order because they get every benefit, right? It's honestly wild. Prosecutors can commit crimes almost and do and not even get away with it. In fact, we'll see what happens to Fani, who obviously committed perjury in court. So this is where it continues. Fani writes, this brief will address that standard of proof recently recognized in Georgia and a few circumstances recognized under Georgia law. Now, as a threshold matter, the elected DA Big Fani is not merely any prosecuting attorney. She's a constitutional officer, and there is only one such officer in each judicial circuit. So it sounds like that Board of Ethics really only can maybe deal with employees, right? But not officers. Maybe it's a separation of powers argument that they're going to get into. Now, under Georgia's constitution, Big Fani is constitutionally mandated to represent the state in all criminal cases. Here, Fani seeks to only do that. She wants to perform her solemn duties under the Constitution. But the defense Mike Roman, Ashley Merchant, and Donald Trump. They ask the court to impose a novel hair trigger standard, which I don't think that's true at all. It's not like any misconduct or $1. It's a totality type of standard, and the indicia add up to it. They say no standard exists here. The true legal standard that they say is clear, that's already set forth by the appellate courts and is confirmed in the statutory language, is much higher. It requires actual, palpable conflict of interest with a substantial basis in fact. And it's like, look, okay, even if you say that's true, even if you come back and say that that is the standard, in other words, like I'm not agreeing that that is the standard, but if it is, they clearly met that. There is a conflict there in the benefits that Fani had. They covered it up. They lied about it. They lied in court about it. They lied on their interrogatories about it. She lied on her gift forms about it. And she paid him $700,000, margins that are much bigger than any of the other two attorneys on there. Is multiple bits of evidence showing that they lied in their affidavit, that their relationship started in 2019 at the judicial conference. Robin Yurdy testified about that before he forgot everything. Terrence Bradley told that to multiple people, including the law professor, including another prosecutor, including Ashley Merchant, in text messages. So there is a clear conflict. They even know there's a conflict because of the cover-up. If there wasn't a conflict, then there would be no reason to cover it up because it would be above board. Now, the standard is high, says Fani, for a reason. The public's interest in seeking justice is in no way served by a low standard that would allow them to invalidate, here you go, the public's choice in their elected DA. And if McAfee punts this, right, that's probably going to be a big basis for it. We have these two levels that we're playing in, the court of law and the court of public opinion. If he decides maybe that the public opinion pressure is the appropriate forum, I could easily see him doing this. Say this was, this conduct appears to me to be egregious, but we have to take Fani's word against other people's word, and she's not credible and they're not credible. And so what I can do is just rely on the process. And so the process presented this case to a grand jury, which are voters in Georgia, and they made the decision on their own to indict this man. And so he's been indicted, and now the case is pending. And even though this conduct appears to be unbecoming of a district attorney, I do believe that it is something that has ended. They've said it's ended. We've seen no evidence that it hasn't ended. And they did this in a way that was not impactful, not material to the underlying case. And so it's not my place, it's not the jurisdiction of this court to make a decision on this. It is my role, adhere to the process. And if anybody wants to bring up any of this stuff in trial, they can, right? Cross-examine the defense or cross-examine the government's witnesses about this, and then we'll let the jurors decide. So the people selected Fani, and the people can elect Fani, and the people can decide, and the people already decided the grand. And so I'm the judge, I'm just going to set it all aside. It's like, oh gosh, make you want to vomit, but you can feel it. You can see, right, how that could happen clearly. And they're persuading the judge with this piece. The people, you're going to disqualify a black female in Fulton County, the most powerful DA in the whole state. Come on, big deal when it's 73% Biden and 20-30% red. And that's not my argument. That's their argument, right? Fani has made this all about race from the beginning, race and God and sexism. So selected by the people to carry out our essential constitutional duties. And our state Supreme Court reinforced this high standard just weeks ago. Says all criminal defendants, this is Fani writing, have certain rights that must be protected by our justice system, but among them is neither the right to be tried by a prosecutor of his choosing. Again, nobody has made this argument. This is such a fake premise. Nobody cares who the next prosecutor is. It's just not Fani, because she is disqualified because she is conflicted off and clearly biased, paying her lover to continue the prosecution. If Nathan Wade did the right thing and told Fani, his lover, said, listen, baby, I love you, but you're a little crazy on this one, okay? You got to dismiss this case. There's no evidence here. What do you want me to do with this? Then Fani would say, yeah, but what about our cruise coming up in March? He's like, oh yeah, I'm getting paid by you. So if I dismiss this case, I'm not going to get that money to take you to Napa Valley. So that's, again, this is not what anyone has asked for. Once Fani's off the case, you're right. Who cares who it goes to? But it's not her. And nor the right to delay his prosecution for no good reason. Another stupid citation. Yeah, you got to have good cause, of course, but it's not a delay. It's a continuance. Now, inappropriate or improper disqualification of a DA like Fani that's elected by the people of this county. See that? We're going to have a lot of this, like democracy, democracy, democracy. And constitutionally mandated to represent the state in all criminal cases has severe consequences, both for the people's faith in their constitutional right to be represented by a DA that they elected, and for the public's confidence in our system of justice, which is wild that they would even put that in a right. Like they would write that on behalf of Fulton County with a straight face. They shattered the confidence in the justice system through and through. For the reasons set forth, they say Trump's motion to dismiss this indictment should be denied. They say, first of all, Trump and Michael Roman and Ashley Merchant, they bear the burden of proving this by a high standard of proof. It is the burden of the party that is seeking to disqualify to prove that it's warranted. True. And that's why we saw this kind of feel like the hearings flipped. We actually got it from originally, right? prosecutors were prosecuting the defense, but because they moved to disqualify, the defense moved, it flipped all of this. And so it felt like the prosecutors were being prosecuted and the defense was the prosecution. But that obviously is not the case. It just flipped things for this hearing and for this issue. So they say Georgia, the Court of Appeals, they recognize that a court considering a motion to disqualify must meet a high standard of proof. How high? At the hearing in this case, they urged the court to adopt a preponderance standard. So back up to our scale that we just drew out up there. It is the low one, 51%, more likely than not. You did it. Evidence tends to show you did it. You're guilty. You're liable. But they say under McGlynn, that cannot be the correct standard. So they say that they want the very low standard, but that cannot be correct. While not squarely addressed in the context of disqualification, they say Georgia have often categorized a clear and convincing showing of actual malice as a high standard of proof. So now they're going, I think it looks like probably a defamation case. So, you know, they're very shady and dishonest. I really don't like how they write this way. They tell us that it's kind of a clear-cut situation, but it's not. It's a case of first impression. And so they're picking out from defamation law to say that this is probably the better standard, right? More like a clear and convincing evidence standard that's a little bit in the middle. And they had to go to a defamation case because there's no case law on point in Georgia, but they keep pretending that there is. Moreover, the 11th Circuit has regularly and explicitly recognized that preponderance of the evidence, 51%, is not a high standard. It's low. Now, the state maintains that the defendants have not established an actual conflict of interest beyond a preponderance of the evidence. But even so, based on these cases, specifically the holding in McGlynn, that trial courts must hold them to a high standard of proof. So the court just said high standard, but they didn't tell us what standard. They said it should be higher than preponderance. So clear and convincing, or even beyond a reasonable doubt, that would be the high standard that Fani would be thrilled about. Now, the defendants, they asked the court to rely on numerous cases. Ashley Merchant, and in this case, John Merchant, her husband, was out there testifying and explaining all this, says that there are cases that they cited, but those are misleading cases. And they actually support our position. They say the defense can point to no appellate case, because there is no case, where an elected DA was disqualified solely based on the appearance of conflict of interest or other appearance of impropriety. So they say that is the standard, like an absence of evidence is evidence of their point. So because no one else has been disqualified under this standard, you can't disqualify Fani either. Indeed, if a case existed, it would have been brought to our attention. Well, it might be because there wasn't ever a DA that had an actual conflict of interest, right? It's kind of insane that we have that. Like, a DA is so corrupt that they have an actual conflict of interest, and we even need to have this discussion. Instead, the defense cobbled together flowery and righteous quotations from inapplicable cases that may sound enticing at first, but that entirely misstate the law in Georgia. And in doing so, the Trump defendants asked the court to adopt a novel legal standard for the disqualification of an elected constitutional officer. A lot of pressure on McAfee that has never before been recognized in Georgia and is contrary to decades of case law. They say there are 5 categories of these cases that they say. Cases that don't concern disqualification at all, but they use for flowery language. There are cases where the defense attorneys were disqualified on the basis of divided loyalty. You know, that's a different situation as well. But let's say a defendant, or there are like 3 different co-defendants and one lawyer represents all 3. Well, that could be a big problem, because what if the prosecutors tell that defense attorney, we want client A to testify against client C? Now you have an actual conflict because you've got 2 clients that now need to testify against each other, and that is not good for one attorney. So the general rule is you got to get off both cases. In violation, now there's other cases where a prosecutor had an actual personal interest or stake, which is exactly what Fani has, or they say personal interest or stake in the outcome of a prosecution, which they want to say it's like in conviction. But of course they had a stake in even filing the indictment. Like, Nathan was getting paid for all the work. If he wasn't moving the case forward, then the case would have to be dismissed. And her interest is in the continuation, the continuity of the case, the creation of the case. It's not in the outcome of the case necessarily. The fact that it was created in the beginning causes Nathan Wade to be paid, causes her boyfriend to have funds to go on vacays with. And you don't want to travel alone. A benefit is having your significant other there. In fact, in tort law, when you lose your significant other, there's a claim called loss of consortium, because you get compensated for the loss of that companionship. So companionship is a real interest. And Fani, of course, had that in spades, but I continue. Now, a single case where a defendant was denied a fundamentally fair trial. So we're going to see a lot of this language if the judge punts this. I don't think it's fundamentally unfair. In other words, the legal work was different from their personal work, and we can separate the 2 out. Where the DA had previously represented the victim in the case, and 5 cases where no actual conflict was shown and where disqualification was not proper. So the first category is the largest, and the court should categorically disregard disregard them in the context of this motion. They say nothing about disqualification of an elected district attorney. So you're noticing all this language, right? Like the people, the election. This is the courts don't dump on democracy theory that they're trying to pursue here, which was very successful in 2020. Remember, we were here talking about all the election litigation and how frustrated we were that courts were not allowing them to move forward into actual discovery and into actual argument. But I think the basis was the judges were trying to find a reason, a way not to overturn the will of the people, right? Not to overturn what they believed, which in my opinion was rigged, but overturn the will of the people unilaterally. And so they're trying to tell the judge to do that too. Don't you dare overturn this thing. It's going to be major consequences for you. Now, cases, they say the second category of cases talks about criminal defense attorneys, right? And so defense attorneys are not elected constitutional officers. And so these cases simply do not apply to the disqualification of Big Fani, who is a constitutional officer whose loyalty lies with seeking justice. No, it does not. Give me a break. Seeking Nathan Wade's and Nathan's hot dogs there in Georgia, not with any individual or private client. They say the Georgia Supreme Court has upheld the disqualification of a criminal defense attorney who had previously been directly involved in the defendant's prosecution, including filing an application for search warrants, right? So the court held that the circumstances implicated 4 ethical rules. So this guy's a prosecutor. He starts prosecuting this guy, leaves the prosecutor's office, becomes a defense attorney, works with the same client that he started to prosecute. Yeah, that's obviously a problem. Now, specifically prohibited that representation because there was a significant risk that his duties to his former boss, which was the prosecutor, could adversely affect the representation. Now, how are they going to distinguish this? They say, yeah, these rules simply do not apply to the circumstances alleged, which is a total cop-out. So yeah, like they're talking about defense attorneys, but standards still apply to defense attorneys. And we're asking ourselves about actual conflicts of interest. And so basically, this guy is saying you can only have cases that are blue triangles. Our case is a blue triangle, and so you can only reference case law that is also a blue triangle. And we say, well, it's not a blue triangle, it's a blue square, because we're talking about disqualification and removal. It's defense attorneys, it's not prosecutor, but it's blue. And they say, well, you have to only have blue triangles. There literally is not a blue triangle because no DA has been this corrupt before. So we have to use blue squares to be persuasive to say that, well, we treat blue things this way. So the remaining cases in this category, says Fani, follow the same logic. In Edwards, a criminal defense attorney was properly disqualified. And we're, again, so a lawyer disqualified. Why? He previously represented the mother of the victim in the case, and neither Edwards nor the victim's mother gave consent to the conflict. So lawyer represents mom of someone who died, someone gets charged in the killing, and the defense attorney also represents the defendant. So there's a conflict there. Now, defense attorneys were disqualified, where members of the firms have also been previously employed as prosecutors and were substantially involved in earlier stages of the prosecutions. So you see, right? The point of this, I think this actually hurts them. I mean, the point is, even a tiny little relationship like that, right? Which is the mother of, I guess it's not that tiny, but represented the mother of the victim. I don't know how long ago that was, if it was years ago, immediate, whatever. That means that he cannot represent the defendant in the case. And he may not even have known, right? May not even recognize that there was a relationship there. That's the point, right? Conflict and bias, it's such a sensitive standard. If it's even a close call, you get off the case. If it's even close. They say in the context of this, courts have considered whether the facts create actual or serious conflicts. And it says a conflict exists if representing a client, if there is a substantial risks. Okay, look at the rules, even read the rules. If there is a substantial risk that the lawyer's own interest or duties to another client, a former client, or a third person will be materially or adversely affect the representation of a client. In the present case, Rule 1.7 is not implicated. A serious potential conflict of interest is insufficient to disqualify. So even the rules, like Fani couldn't discipline Nathan as she could a normal employee because she was sleeping with him. She's got love for the dude. We saw her enamored with this guy when she was testifying on the stand in Fulton. So she's got a personal interest in him, in the prosecution, in him continuing to get paid. And we're going to see the defense respond to this in a minute. A defendant's conviction was reversed because his defense attorney accepted a job with the DA's office, right? That's a conflict. The record did not establish that he had disclosed this, and he asserted on appeal that his future employment would be affected by his decision-making. So all of that, right, is an actual conflict, and so that person had to be removed. Now, while that case also refers to, quote, an appearance of impropriety, it is factually distinct, and so we need an actual conflict, not an appearance of a conflict. The third category is saying that prosecutors got personal interests in the proceedings. This one was a civil asset forfeiture where they were paid on a contingency fee. We heard Ashley Merchant talk a lot about this one. Now, this case also refers to the appearance, okay? Appearance, not actual. Conflict of interest. They say this case was ultimately decided on public policy grounds, not on conflict of interest grounds. So this case is inapplicable. You can't use it, defense, to support that the standard is just an appearance, not actual. So that reference is dicta, they say. They say the application of the standard was merely assumed and explicitly did not adopt it. Okay. Now, in the remaining cases in this category, they say disqualification was appropriate because there was an actual conflict, which I think there was an actual conflict here, but they don't. Special prosecutors were in a criminal contempt case. They were disqualified because the prosecutors also represented the plaintiff in a civil injunction, and they had the power of the prosecutor's office as a bargaining chip in their civil negotiations. Yeah. Just like Fani has the power of her personal relationship over Nathan Wade, right? It's conflicted, and he does too. The Solicitor General was disqualified from prosecuting Nichols, and as this court also pointed out at the hearing, and these cases demonstrate to create disqualifying conflict of interest, a prosecutor's alleged, quote, personal benefit, it must be material. There must be some factual relationship, and we're going to see what Steve Sadow says about this, between the alleged benefit and the prosecutor's involvement in the case to show a personal stake or interest in the outcome of the proceedings, which I would say is the continuity of the proceedings, not necessarily the outcome. They get paid either way. Obviously, they want to win, but the indictment itself was the initiating moment, was the event that brought in the contract and brought in a bunch of money. Here, Trump has not even alleged, and certainly not proven, that the DA received any benefit contingent upon the outcome of this case, which I don't think is the point. The fact that if the case never came, then we wouldn't be here. So I guess it is contingent on you filing the case, but it's not contingent upon the outcome of the case. Again, whether they win or lose, Nathan Wade gets paid either way. And the only way that he does not get paid is if he dismisses this, because then he has nothing to bill against. So it is contingent upon the outcome of the case. Like if he dismisses this, if they turn around and dismiss this with prejudice and say there is no charges here, okay, all this is moot. We'd agree with that. But it is contingent. It's contingent on the continuity of the case. A nebulous alleged benefit, it's not nebulous, is either not personal or two, not directly tied to the outcome of the case. Traditionally, the conviction of the defendant, which is what they say traditionally, so that's a little cope word right there. He realizes it's not the conviction. It's even the judge brought this up in the hearing, which is why this is dishonest. He said, okay, so like if it's a motion to suppress, is that enough? He says, well, yeah, you can't incentivize people on a motion to suppress. Okay, how about we back that up then? How about an indictment in the first place? Can you incentivize people on indictments? No, you can't. Well, that's what Fani did. Sorry, that's what she did. She incentivized him to bring an indictment so that he could get paid. So there is a contingency there. He says it's not enough to warrant disqualification. I disagree. Now, disqualification is not appropriate where criminal charges have no factual connection whatsoever to the interest. They say otherwise, as this court observed at the hearing, any alleged improper personal benefit that Fani got under any circumstance would disqualify her from prosecuting every case in which she signed her name to the indictment, and that is obviously an unworkable interpretation of the law. That's a straw man. Okay, nobody made that argument. Nobody said Fani Willis, takes cookie from someone when she's, walking around a convention. Oh, that's a cookie's a benefit. You're going to get disqualified from all your cases. That's not the argument. This is stuff that reaches a materiality, and it's a clear benefit that was given on the back of a criminal prosecution. That's where the conflict is, and we're going to see more about that. They say the fourth case is a single case. It concerns a defendant's right to a fair trial. In that case, the court held the defendant was charged with shooting her estranged husband. They said she was denied an unfair trial. Why? The DA had previously represented the husband in the divorce proceedings, and the DA was cognizant of information and incidents that occurred between the victim and knew about this for the divorce proceedings. And the DA sat at counsel's table for the entire trial. The court held that, yeah, public policy prohibits a DA from prosecuting a case while also representing the victim of the criminal act. And you can see how this stuff is kind of crossing the V. The verses, you've got, party A versus party B. And a lot of these conflicts are crossing the table. So what Fani is going to say is that our conflict was contained within one side. Our conflict didn't spill over into Donald Trump, which I think is basically what this argument is. But the facts and the legal principles in Davenport are too far remote to be applicable here. And the final category from Fani's team says that they rely on cases where disqualification was not found to be proper. So a special prosecutor accepted future employment with a law firm, previously represented a prosecution witness, but that was not grounds for disqualification because no actual conflict was shown. They say Georgia Supreme Court has said that an actual conflict is required to warrant reversal for failure to disqualify. So that's a reversal standard after the conviction, right? This is post-conviction. And that's what I think Judge McAfee was talking about. This is pre-conviction, not post-conviction. Reversal. Now, not just the appearance. Now, a DA's office investigator also had a close personal friendship with the victim, said that that was not grounds for disqualification. So the DA's office investigator had a relationship, right? That's not the prosecutor. And a prosecutor's statements to the media after a hung jury, again, saying the score is 35-1 for conviction. That did not amount to forensic misconduct either. And again, that's after the verdict. So all of these are after the verdict. So none of these cases suggest that a DA may be disqualified based on anything less than an actual conflict of interest. But those are after the verdict, okay? It's a whole different category. So that's not what they're using them for. Anyways, we continue. They say multiple Georgia Supreme Court cases clearly established that Georgia courts are not authorized to disqualify an elected DA absent an actual conflict of interest, they say. There are generally two recognized grounds for disqualifying. First is based on a conflict of interest. The second is forensic misconduct. So we got number one here, conflict of interest. Number two, forensic misconduct. Under Georgia law, conflicts of interest have only been found where a prosecutor previously represented the defendant with respect to the offenses charged. Okay, so that's again across the V. So A versus B, that is a prosecutor who is originally representing B. We'll call B the defendant. So the prosecutor's over here, but then he moves over here. So he crossed the V. And they're saying that has consulted with the defendant in a professional capacity where the prosecutor has acquired a personal interest or stake in the outcome of the proceedings. No other disqualifying conflict has ever been recognized under Georgia law. And moreover, as Georgia's Supreme Court again reiterated less than a month ago, an actual conflict of interest is required. The trial court did not abuse its discretion by failing to disqualify them absent an actual conflict. They say McAfee, Fani's office, says this has been the unchanged law for decades. In another case, the Supreme Court also said that the trial court erred in disqualifying an attorney based on the appearance of impropriety that resulted from the fact that two lawyers representing the opposing parties in the matter were married. All right. So again, across the V, you got, one spouse, two lawyers representing both people. They're married. There's pillow talk. It's not good. The court recognized that although the issue has never been squarely addressed in Georgia, courts in other jurisdictions have rarely been willing to disqualify an attorney based on the appearance of impropriety alone, where there is no danger that the actual trial of the case will be tainted, which obviously this case will. Now, the court reversed the trial court and rejected the notion that trial courts are authorized to disqualify based on the appearance of impropriety. So again, they're saying the standard should be above clear and convincing, and it should be actual conflicts. They say the Georgia cases cited do not stand for the proposition that a trial judge is authorized to disqualify an attorney solely on the basis of an appearance of impropriety. So maybe not solely, but with other indicia. They say the court did not restrict its language here, and based on our reading of this case, no appellate case in this state has, before or since, ever authorized a trial judge to disqualify a prosecutor solely based on the appearance of a conflict of interest. And this concept is reinforced in other cases. In this other case, the court also reiterated that a theoretical or speculative conflict will not impugn a conviction, again, post-conviction case. Now, while Lamb did not involve the disqualification of a DA, they said there must be a palpable and substantial basis in fact. Do you feel that Fani's misconduct is palpable, my friends? Gross. Decisions of the Georgia Court of Appeals are in accord. The court affirmed the trial court's denial of the motion, saying that there needs to be an actual conflict. Something that's theoretical or speculative is not sufficient. But every Georgia case that has addressed this issue has reached the same conclusion. If you want to disqualify, it must be an actual conflict. No prosecutor has ever been disqualified on the appearance of a conflict. They say the cases set forth continue. Must be an actual conflict, and we are repeating ourselves here because they are. They say, hey, and by the way, we're sick and tired of Steve Sadow and him talking about Caesar's wife, okay, Julius Caesar's wife. He says references to Julius Caesar does not lessen the requirements. He says at the hearing on the matter, the court also referred to the occasionally invoked example of Caesar's wife, who's supposed to be beyond reproach. The language to which the court referred was first used in Nichols versus State. They said the administration of law, this is a quote from case law, the administration of law, and especially that of criminal law, should, like Caesar's wife, be above suspicion, should be free from all temptation, from all bias, from all prejudice, and so far as it is possible for our courts to accomplish. Now, the court noted this language and said whether it suggests that something less than an actual conflict of interest should be sufficient. But the state has not found any case that ever made such a holding. And Georgia went out of its way to reinforce that there are different standards. Shortly after quoting the Caesar's wife language, the court explained that if he were compelled to proceed with the same circumspection, there would be an end to the conviction of criminals. So if the standard is too low, then you can disqualify DAs for everything. And that becomes a bit difficult. They say this case also acknowledges the example of Caesar's wife, and it emphasizes that prosecutors are not held to the same standard as judges. Instead, prosecutors can only be disqualified in cases where they're acting in their own personal or individual interest rather than in the character of an officer, and someone charged to perform a duty. And clearly Fani was doing this, right? Appointing her boyfriend so she could hang out with him at their anti-corruption meetings and have multi-hour lunches with the man she loves. Sutherland also says that in an example of private prosecution, a contingency fee, it's not just about money. Contingency fees like personal injury cases, right? Personal injury case, you get a settlement. The attorney only gets paid if there's a settlement. They take a third or whatever it is of the fee. But that's an example of actual conflict. Now, indeed, every case the state has found involving disqualification of a prosecutor based on a personal stake or interest, that personal interest has consisted of the prosecutor enjoying money gain contingent upon the outcome of a criminal case. So the elements, right, the different checkboxes, they say it's got to be money. Without that personal interest, so having your boyfriend with you, going on the cruise, is none of that. It's money. Only that is sufficient to displace a prosecutor. Now, for the reasons set forth, they say this court should not disqualify Fani. Last minute filing skidding in here because the court fails to demonstrate an actual conflict or forensic misconduct. And to whatever extent the defendants allege that the DA received a benefit, they have made no allegation. They've offered no evidence that she has any improper, direct, or material personal stake in the outcome of these proceedings. And it's in the continuity, right? It's in the prosecution in the first place, sufficient to authorize disqualification. The defendant's suggestions concerning what constitutes an improper personal stake or interest are both unsupported by law. The court rightly points this out. They're entirely unworkable. If you apply the actual legal standards as set forth in Georgia, there's only one outcome. The indictment should not be dismissed, and Fulton County and Big Fani should not be disqualified. Signed by Fani Willis's office, Adam Abate, you remember him, objection, privilege. John Will Wooten, sent into the court, and they are, as you can see, really trying hard to change the rules of the game to suit them. And we talked about these standards. They want it to be as high as possible, up near the beyond a reasonable doubt standard, 90%, 80%. And they also want these checkbox, the elements of the disqualification, whether it's actual conflict or impropriety, they want it to be more towards the actual conflict, so it's much harder to prove. Much more checkboxes, much higher standard, and they're going to see if they can basically cajole Judge McAfee into doing it by floating around this language about the elected people of Fulton County and Georgia and democracy and all those things. Well, Steve Sadow responded to this, and it's only his initial response. Trump's defense submits an initial reply to Fani Willis's last-minute attempt to state on this case. He says, all right, Your Honor, McAfee, President Trump's initial reply to that brief that we just read addresses only the argument on forensic misconduct, Steve Sadow writing. In a footnote on page 2 of its brief, Fani says, they said, the evidence presented in this case does not even come close, says Fani, to establishing that the DA's statements were part of a calculated plan, evincing a design to prejudice Trump and the defendants in the minds of potential jurors, and that's the standard that's required for forensic misconduct. They say no prosecutor in Georgia has ever been disqualified from prosecuting any case on grounds of forensic misconduct, and this case should not be the first. That's what Adam, Fani, and Will all sent in. But Williams, they say, that case does not set that as the sole test for the standard or the standard for all types of forensic misconduct. Let me educate Will on what the law actually says. Here's what the case actually says from Steve. One of the primary examples of forensic misconduct consists of the improper expression by the prosecuting attorney of their personal belief in the defendant's guilt. Wow. Williams' case says that? Improper expression. Now, in determining whether an improper statement of the prosecutor as to the defendant's guilt requires his disqualification, the courts have taken into consideration whether those remarks were part of a calculated plan, evincing a design to prejudice the defendant in the minds of the jurors, and whether such remarks were inadvertent, albeit improper, utterances. So they left that out of their brief, didn't they? That's a pretty good opinion and pretty good evidence there, because Fani Willis talked at the church twice as part of her conspiracy to blame the co-defendants who were calling out her affair as racist and bigots. Says, our case, Judge McAfee, Steve Sadow writing on behalf of Trump, he says, our case implicates far more appalling and unforgivable types of forensic misconduct, like these: deliberately stoking racial and religious prejudice against defense counsel, their lawyers, and the defendants, and testifying under oath untruthfully, lying to you, and committing fraud upon the tribunal, all done in the prosecution of the defense. How is that for an actual conflict or actual prosecutorial misconduct? In this case, forensic misconduct. It involves the elected district attorney, Fani, wantonly playing both the race and the religious card in her extrajudicial MLK holiday church speech. This was part of a calculated plan to prejudice the defense counsel and the defendants in the minds of the Fulton County jurors. And two, Fani Willis and her then lover that she hired, DA Wade, testified falsely in a hearing before this court on material factual issues. They lied about whether their personal relationship began before Wade was even hired. All false. Affidavit said relationship started in 2022. Robin Yurdy said 2019. Terrence Bradley said that too in his text messages to Ashley, told a prosecutor that, and also told a law professor that. Now, the cell phone records corroborate that. So while the state claims that no prosecutor has ever been disqualified in Georgia for forensic misconduct, guess what? There's never been a Fani before. Okay, no prosecutor in Georgia, elected or otherwise, has engaged in misconduct like Willis or Wade have here. That's why you don't find any case law. Elected DAs, and whether she's a constitutional officer notwithstanding, the remedy must fit the misconduct. This court must not permit Willis and Wade to continue to prosecute this case. They have flouted and violated the Georgia rules of professional conduct as lawyers, 3.3A1 and 3.8G. And to do otherwise will be viewed by the public and within the criminal justice system as an open license for prosecutors to engage in flagrant and egregious misconduct without repercussion or appropriate sanctions by the very court before which this misconduct occurred. Steve Sadow response says dismissal and disqualification are the appropriate remedies here, and we have chronicled it in depth. And so there are more responses to Fani's brief, which of course we are going to get to. But Fani files this last-minute brief trying to get Judge McAfee on his heels a bit, saying maybe I should apply their standard, maybe the burden of proof should be much higher, maybe the elements of the law require what Fani says that they should require. And now that McAfee has a political contender who apparently is jumping into the fray, and we have new complexities entering the game, we'll see what he decides to do. Of course, we're going to be here covering this trial and all the rest of them, my friends. So if you're joining us, thank you for subscribing. Thank you for hitting that like button. Thanks for checking out some of the links down in the description below. We have our new calendar online at robertgovea.com. So if you want to check out what's coming up and add the calendar to your phone or to your work calendar, you can add the show. You can add all of the hearings that are coming up and all the Trump trials. Go to robertgovea.com, click the calendar tab, and you'll see it there. And we'll see you back here on our next one.